Welcome, everybody. As I said, my name is Neil Ward. I'm a partner here at Mills Reeve Solicitors. So thank you very much for joining us on this, our second webinar. We had one yesterday, if you were not able to join us, regarding the broader changes that are proposed to the Mental Capacity Act through the Code of Practice. Today, we're going to be focusing on the change from the deprivation of liberty safeguards to the new liberty protection safeguards, which is, of course, in many ways, the biggest part of the change that's proposed. If you're joining this webinar today, I suspect you already know that the government has recently gone out to consultation on a proposed new code of practice, along with a consultation document. The code of practice new one is pretty hefty. It's quite a long document. But if you want something a bit more manageable, there is a helpful about 25-30 page consultation document which has a summary of the main proposed changes and a number of questions. We would encourage everybody to respond to the consultation. It's open for another month or so. It's beginning of July, so there is still time to respond, and we'd certainly encourage you to do so. So today I'm joined by three colleagues, Jane Innes, Jill Weston and Molly Sanghera, who are going to talk each for about 10 minutes. And that should give us about 10 or 15 minutes at the end to have questions. Please do feel free to put questions in the Q&A box. We will, because of the time, relatively short time constraints, we will take questions at the end. But if you think of a question as we're going through, please do pop it in the Q&A rather than the chat box, and we will pick up those questions at the end. The session is being recorded, and you will get a link to the recording and also the slides shortly after this, next few days after this webinar, and we'll also get a recording of yesterday if that's helpful. We would also ask you, if you don't mind, to fill in feedback at the end. It literally takes about 30 seconds. It will pop up at the end of the webinar, and if we could give us any feedback, that would be very much appreciated. Okay, I think that's everything from me. So I will now hand over to Jane, who is going to be the first of our speakers. And thank you very much. Over to you, Jane.
Good morning, everybody. I'm going to talk to you this morning about what is out for consultation, the sort of how, what, why, when aspects of this, and the timeline for the implementation and some of the resources that are available to you. Next slide, please, Debbie. So firstly, as you all know, we're going to talk about the LPS, which is going to take over from the Deprivation of Liberty Safeguards. DoLS is the current system in place at the moment, and it is now considered considerably outdated. And therefore, we are implementing, hopefully, the LPS into to being. So it's not a new concept. It's introduced into the Mental Capacity Amendment Act in 2019, and it's implemented into the draft new code, which has lots of additional sections regarding this. New slide, please, Debbie. So as I said, the current DoLS is outdated, and it's now been for a long time that it has been decided that this new system needs to come into place. It's broken and bureaucratic and left thousands without protection. So, as I said, it's been implemented into, it was mentioned into the Mental Capacity Amendment Act, but it's not yet in force. Next slide, please. There's also the new draft code of practice. So what is changing? Previously, there were two codes. There was one main code for the Mental Capacity Act 2005 and a separate code for the Deprivation of Liberty Safeguards. There's now out for consultation a new draft code of practice, which integrates the sections relating to the LPS and the sections relating to the Mental Capacity Act 2005 into one document. Previously, the two codes were 426 pages Now, this new single document is quite hefty at over 500 pages. I just wanted to remind everybody that the code is statutory guidance. That means that this is setting out what the government thinks how the MCA should work in practice. For example, in relation to time frames, the Act is silent on this, but the code sets out that it should be within 21 days. So basically, it's setting out key matters such as best interests, and professionals should have regard to it. Next slide, please. So, what's out for consultation? So basically, as Neil said, there's a consultation document in the draft code of practice. There are also LPS regulations that have been published. The LPS regulations are not out for official consultation, but they are to help aid the consultation process. The government wants feedback and is really interested on everybody's views on this. And as Neil said, it's really important for them to understand exactly what professionals working in this scenario are experiencing and have lived experience of. The consultation documents were published jointly by the Department for Health and Social Care and the Ministry of Justice on the 17th of March. And as Neil said, the consultation ends on the 7th of July. The question of why. So basically, the government wants to stress test these documents before they're put before Parliament, because it's a large reform process which will involve significant changes for the health and social care system and the people who rely on it. It's important, therefore, to carry out this stress testing to ensure that it's as correct as possible before it's adopted by Parliament. Next slide, please, Debbie. So the documents that are out for consultation, there's a really helpful government web page, which is where all these documents can be found. And the link to this is at the top of the slide. So, as we've already said, there is the draft code of practice. The changes to the MCA code of practice and the implementation of the LPS are written into the consultation document. This consultation document is a lengthy document. It's split into 5 sections, and it has a series of questions and scenarios that the government would like feedback on. Also, as Neil mentioned, there are 2 easy read summary booklets, which cover a sort of shortened summary. The first is a summary of the wider MCA guidance, which is not directly relevant to the LPS. However, there is a summary that is specific to the LPS, which, if you don't have time to read the whole lengthy document, it's an easy read document with bullet points that list the changes and a list of questions and scenarios for people to answer. As I mentioned before, there are 6 sets of draft regulations that have also come out. The draft regulations are there to help support the consultation process. 4 sets of these apply to England only, 2 sets apply to England and Wales, and the Welsh Government has published 4 sets of its own. And it is considered that the 4 sets that are published out by the Welsh Government might be useful in providing additional information, and therefore it would be perhaps sensible to look at these as well. Also, this page and the government has published a series of documents to support the sector in implementing the LPS. And these are a set of documents that come through, and they have titles which are very self-explanatory, really. So, an impact assessment, which looks at how the financial constraints and the financial burdens might impact on the sector. The LPS workforce and training strategy, well, that's what it says on the tin. It basically sets out what different organisations could do to begin preparing for the implementation. The national minimum data set is talking about the standardisation and collection of the information going forwards. What they're hoping to do is to merge the current two different sets of systems into one. And lastly, the training framework recommends specific subject areas that should be covered in training in the sector. Lastly, engagement events. The government published the idea that actually it wanted to hold some events that were small roundtable meetings between themselves and people who had lived experience of this system, and they wanted to hear how they could possibly go forwards and implement changes of people using their experience of practical situations and individual circumstances. This is now closed, but I am sure that some of you may have already registered to attend these events. Next slide, please, Debbie. So basically, the timeline here is, as you can see, this has been published. So we're out in the consultation period at the moment. This was originally going to be 12 weeks. They extended it due to the extra bank holidays, and also we were given the extra bank holiday for the Queen's birthday. So it's now ending on the 7th of July. Then during the summer and the winter, there'll be consideration of the consultation responses, and the government proposes to provide and publish its response this winter. And then obviously next year, they will be looking to implement the launch of LPS. So the only last thing to say is, as Neil said at the beginning, it's really important that people give their views to the government to inform this, because once it's adopted by Parliament, it will be very difficult to change. So therefore, it's essential that, if at all possible, they have as much feedback on all of these documents as possible. I'm now going to hand over to Molly, who's going to talk you through some of the specifics.
Thank you, Jane, and good morning, everyone. So it's been a long time coming. We've finally got some meat to the LPS process. So what do we need to know? First and foremost, if you haven't already, and if you look at nothing else, have a look at the code, specifically chapter 13, so you can understand what this is. The code is so detailed, and I've got it up in front of me, and there's lots of information. So you need to just take time and have a look at that. And I would really also emphasize, as Jane said, to respond to the consultation questions where you can, because as we've already experienced, if the system isn't working, we're just going to have the same problems again. So we want to try and move away from that. So chapter 13 is the starting process in terms of what is LPS. It sets out the stages of the process, who needs to be involved and at what stage. The process is going to be triggered if the proposed arrangements amount to a deprivation of liberty. Helpfully, there's going to be a new definition, but I'm not going to go into more detail on that. Jill will break that down a little bit more shortly. But what's interesting and what the code says specifically is that if P's care or treatment is arranged under a different framework, and during those assessments, whether that's just a care planning review or a Care Act assessment, if you identify during that somebody is deprived of their liberty, that may well trigger the process for review under the LPS system. But rather than then holding a whole separate review, the code wants us to combine this. combine the LPS review within the other assessments that you're doing. So don't hold separate meetings. If you're undertaking a mental capacity assessment, ensure that it also covers care and residence. Does the individual have capacity to understand where they are, where they're living, what their care arrangements are? Then again, as ever, best interest, if they lack capacity, is this the least restrictive option? So undertake all of that alongside your other reviews. The aim of this is to try and ensure that we're making this less onerous for the individual and less bureaucratic. We want to try and streamline peace care and make it a smoother process and enable better engagement going forwards. So as part of the LPS process, we're getting lots of new acronyms, and we love acronyms. And I'm going to talk about the next one, the first one. The next slide, please, Debbie. So chapter 14 tells us who a responsible body is. So that's our first acronym, RB. This is going to be an organisation rather than an individual. So that may be an NHS trust or foundation trust, a local authority, a CCG. If we're in Wales, it may be a local health board or other. So the responsible body is going to have general duties to publish information about the effect of authorisations, set out what their process is, where an IMC should be appointed, role of an appropriate person, our next acronym, AP, and then our third acronym, NAMCP, where everybody should be involved, how you have the right to make an application to the Court of Protection, and how your authorisation should be reviewed. So when we look at who should be the responsible body, Schedule AA1 has been introduced to the Mental Capacity Act, and it sets out a hierarchical list of who this should be. Interestingly, the code says that in most times this should be quite simple to identify, but if the LPS is being requested to cover different settings, this is where we may have to dig a little bit deeper to find out who the responsible body should be. And within the code, chapter 14.3 discusses this further. And what it says is that where the authorisation covers different settings, the identity of the RB needs to be determined by reference to the criteria in Schedule AA1. And they provide some questions to help us consider who this should be. So one of the first question is, are the arrangements being carried out mainly in an NHS hospital? If so, in England, the RB will be the trust or the foundation trust. If it's Wales, it will be the local health board. Second question is, are the arrangements being carried out mainly in an independent hospital in England? If so, the RB will be the local authority who's meeting the person's need, or the local authority in which the hospital is situated in. Third question is, are the arrangements being carried out mainly in an independent hospital in Wales? If so, it's going to be the local health board for that area in which the hospital is situated. Fourth question is, are the arrangements being mainly carried out through the provision of NHS continuing healthcare in England or healthcare in Wales? If so, it will be CCG in England or the local health board in Wales. So really easy, isn't it? I don't know about you, but I've got slight flashbacks of who pays coming up here, but we will see, and hopefully we'll be able to ourselves through this. And then the final question it says is that in all of the cases, the responsible body is the local authority. So nice and simple, and we haven't really got to worry about it. So for that alone, again, we really need to be clear on who is doing what from the outset. But what the code also says is that just because the wrong responsible body has been identified doesn't mean that the LPS process shouldn't continue. That can get sorted in the background. Priority is sorting P out, and then you can deal with the correct responsible body in the background. Next slide, please, Debbie. So our second acronym, an appropriate person. So 1.2 reps, if it was a community DoL, RPR, they're gone. Our new person is the appropriate person. And again, chapter 15 goes through this in more detail. So it's a statutory role, and the AP has to provide representation and support to P through the process of the review and during the authorisation. It should ideally be somebody that's close to P, so they need to be able to be somebody that's not involved in their care and treatment, but somebody such as a family member, a friend, a volunteer, a carer, sorry, not a carer, an LPA attorney or a court-appointed deputy. So somebody who is there on the fringe, but not involved in the day-to-day care and treatment. But what the code also says now, in terms of the appropriate person, is the responsible authority body needs to sign off on the appropriateness of the appropriate person. So it's another check for the responsible body to be doing. In terms of approving them, two things particularly that the responsible body needs to do is make sure that the AP has consented to taking on the role, and also make sure that they have capacity to be able to take on that role. We also have our third acronym, the Approved Mental Capacity Professional. So this is a specialist role, and whilst not being used all the time, an AMCP may come in where there's a reasonable belief that P doesn't wish to reside or receive the care or treatment that they're predominantly receiving in an independent hospital. So whilst it may also be the case that you look for a referral to an AMCP within an NHS trust or foundation trust, particularly this is designed for the independent hospitals as a greater level of scrutiny and support for P. So the AMCP can be a nurse, social worker, psychologist, speech and language therapist, or occupational therapist. But to be an AMCP, they will need to complete training and seek approval from the local authority before they can practice. So no doubt, in practice, once we get to this stage, the local authorities will hold lists of AMCPs. So this is about all organisations working together to ensure sharing of that information and making sure those lists are up to date. So the actual meat of it, if we go to the next slide, please, Debbie. So what is the process? Luckily, it's not completely reinventing the wheel, but very helpfully, the code reinforces that P should be at the centre of the process. So it's ensuring that we obtain P's wishes and feelings. The responsible body should be consulting anyone that's interested in P's welfare. And this is during the initial authorisation, whether there's a variation, and also prior to any renewal. So again, not completely unknown and different to what is already being done. During the process, P can be supported by the AP or an AMCP if that's needed. Unsurprisingly, document all your evidence, whether that's mental capacity assessment, best interest meeting, discussions with everyone, it all needs to be documented. Then there are 3 specific assessments that need to be completed. So I've already talked about it, mental capacity assessment of whether P lacks capacity to consent to the arrangements, medical assessment of whether P has a mental disorder, and an assessment of whether the arrangements are necessary to prevent harm to P and they are proportionate to the likelihood and seriousness of harm to P. Bit of a mouthful. In order to have an LPS authorised, all the conditions need to be met for the RB to grant the authorisation. So if one of those assessments is not done or doesn't provide the requisite answer, you won't have an LPS in place. And if you go to the next slide, please, Debbie. So is there a massive difference with variations and renewals? The short answer is no. If there's a variation needed, undertake a review, hold a meeting to understand what those changes are. Are they more restrictive or less restrictive? Document it. If it's less restrictive, you may not necessarily need to change anything. If it's more restrictive, you may need to update the paperwork. Same with a renewal. When it's coming to the end date, the RB has to be satisfied that the conditions continue to be met. In order to make the process less onerous, the LPS system is proposing that you can renew the LPS without further assessment. So you can utilise previous assessments for the renewal. But to do that, you need to ensure that there are no significant changes. So again, there will still need to be some element of a review with the professionals involved in PE's care. If the RB isn't satisfied with that information, you may need to do the whole process again and undertake full reviews. And again, the same will happen if there's been a substantial change in their care. So that is a very whistle-stop tour through what the LPS is going to look like and some key highlights. And now I'll hand over to Jill to go through what exactly is a deprivation of liberty.
Thanks, Molly. Good morning, everyone. I'm going to deal with what is currently in Chapter 12 of the Code, which is out for consultation, which is what is a deprivation of liberty and how is it identified. And helpfully, this builds on what we already have in terms of the acid test from Cheshire West, but there are a few slightly peculiar tweaks and references to what I think was probably the previous comparator position that those of us who are old enough to remember life pre-Cheshire West had to consider when we were looking at the old style deprivations of liberty. But Chapter 12 is surprisingly easy to read. It's quite well drafted. And if you look at the consultation questions that exist and have been put out in relation to it, they're very, very straightforward. It's effectively, is Chapter 12 clear and easy to understand, or is it confusing and do you want changes? So everything that comes next carries the caveat that the code is not yet finalised. So some of this might change, but in broad terms, this is the shape of what we're looking at in terms of a deprivation of liberty. So Chapter 12 sets out the components of a deprivation of liberty, but sadly, possibly helpfully, it's the way in which those components are applied to individual factual circumstances that remain effectively the essential bits to consider when looking at whether you've got a deprivation of liberty that needs authorisation under LPS or whether you've just got a restrictive care package. And the important elements of that are whether or not an individual has freedom to leave the place in which they are being cared for, whether they're under continuous supervision and control, whether they are able to consent and have capacity to consent, and some bits and pieces in relation to medical treatment, which cover some of the circumstances that threw up some queries over the last 5 or 6 years in terms of whether or not treatment in particular circumstances would or would not amount to a deprivation of liberty within a hospital. But essentially, there are 3 components to whether or not a deprivation of liberty is something that needs authorisation under LPS, and they are thankfully familiar. Whether the individual is being confined in a restricted space for a non-negligible period. That's the objective element of the assessment. Whether there is no valid consent to that particular form of care, that's the subjective element, and whether the care package itself is imputable to the state, and that's the state imputability element of the package. And those pretty much map over onto the acid tests that we've got from Cheshire West, the continuous supervision and control, not free to leave, imputable to the state. So I'm going to deal with those in a little more detail. The next slide sets out what amounts to confinement, and helpfully or unhelpfully, the code confirms that this will be fact specific, as it currently is at the moment, and will include consideration of these 4 points. So, is the confinement within a restricted area for more than a negligible period of time? There's a sort of fluidity to this in terms of the longer the confinement, the more likely it is to be a deprivation. But if the nature of the restraint is significant, then you need a shorter duration for there to be a deprivation of liberty. So none of these factors can be dealt with in a sort of checklist, tick, 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 tick. You look at the way in which they combine and interact with each other to give an overall factual matrix that may or may not amount to a deprivation of liberty. So you need to look at the duration. How long are they going to be confined? What is the effect of the confinement on the individual? Are they aware of the fact that they are being confined? Are they being restrained? Is there any use or threat of force being applied? Are they distressed by the confinement, or do they not know that the front door is locked and they're not able to leave? Are they trying to leave? There are a whole load of factual considerations that need to be woven into looking at the confinement, and you have to look at everything. In terms of the freedom to leave, this is a fact-specific point again, and freedom to leave in the code is explained as whether it is the ability to leave permanently, not just the freedom to pop to the shops and come back, either with or without an escort. But if P chose to leave a particular place and go and live somewhere else, would they be permitted to do so? One of the slightly complicating factors here, I think, is that where P is in their own home and they choose to be in their own home, or they previously expressed a wish to be there, what the code says is that freedom to leave is not necessarily as relevant for a home care package that may amount to a deprivation, so the current REEX type process, as it will be where an individual is being cared for in another location. So there's a suggestion here that choice or previously expressed wishes may be relevant to the assessment of whether there is or is not a deprivation of liberty that needs an authorisation. Continuous supervision and control, the code is very clear, are two different concepts, and both need to be present for there to be a deprivation. There is a considerable degree of overlap between these two, but set out on the slides are the difference between supervision and control. So supervision is the monitoring or observation of an individual, and control is the degree of decision making that somebody external to P has about effectively activities of daily life, location, contact, restraint, and so on. And what is central, and quite interestingly central within the code of practice, is the degree to which P's wishes and feelings are being facilitated to determine how much control is being exercised. So is P able to make choices about their activities, who they see, when they see them, under what circumstances? And if there is a degree of choice and control being exercised by P, even if they don't have full capacity to do that, the suggestion in the code at the moment is that that might not amount to a deprivation of liberty, depending on the underlying factual matrix that sits behind that. So consent is quite important in relation to this, because the individual needs to not be able to consent to the confinement, because that's part of the assessment of the deprivation. We don't have time today to deal with the detailed issues of consent, but what is fundamental is that it requires detailed knowledge of the Mental Capacity Act and the relevant sections of the code, which are in chapter 4 of the new revised document, and that the consent we're dealing with has to be from the individual themselves. it can't come from an LPA. It has to cover all of the usual things. So is there an understanding of the arrangements that are going to be proposed and how those are going to be implemented? And the code is also quite clear that where you're looking at domestic setting arrangements, so the REX type of situation where someone is in their own home, consent and the degree of consent that has been given or advanced care planning that's been put in place is likely to be much more important and central to the assessment of whether there is a deprivation or not. So that takes me neatly on to the next slide, which is advanced consent. And this is effectively an extension of the advanced decision type progression that we've seen in relation to care planning in other areas being extended into deprivations of liberty. I suppose the takeaway in relation to this is that if you have advanced consent to a restrictive care plan that is being implemented, what the code says is that will not be a deprivation of liberty and no LPS authorisation will be required. So if you have got someone who has previously expressed some very clear views about what they want to happen if a restrictive care plan is required, if you can deal with that by way of advanced care planning, then you don't need an LPS authorisation. And there are similar restrictions applied to the way in which that planning needs to be put in place as there are in relation to advanced decisions. So it has to be clear, applicable, effective. It's valid from the age of 16 upwards. Interestingly, it should be in writing for a deprivation of liberty and LPS authorisation not to be required. And it will be very interesting to see what emerges in the code after the close of the consultation in relation to that, because it's quite an interesting idea. State responsibility is effectively unchanged. So any care package that is or should be known to, arranged by, organised or authorised by any of the state organisations, local authorities, hospitals, authorised by the court and so on, is likely to be imputable to the state. And there is a duty on all of those organisations to determine if there is a deprivation, and if there is, to take steps to bring it to an end. So the first port of call is you explore whether or not the deprivation of liberty is necessary. And if it isn't, you end it. But if it's not possible to safely manage P without there being a deprivation of liberty, then there needs to be an authorisation through the LPS process. The position in relation to medical treatment, which is set out on the next slide, seems to be heading back to the comparative position, which was pre-Cheshire West, which is, are the restrictions that are being applied commonly occurring and materially the same as would have been provided to someone without a mental disorder? And if the answer to that is yes, then there's unlikely to be a deprivation of liberty. So that's a slight shift from where we are now. And some of the examples that are set out in the code, and the code is full of them, are slightly harking back, I think, to where we were pre-Cheshire West, not only in relation to the medical treatment, but also in relation to deprivations of liberty that need authorisations generally. But as Jane and Molly have both said, I would encourage you all to read the consultation document. If you only read a couple of chapters, then 12, 13 are good places to start, and just see how you feel about what is in there and what the guidance is, what the examples are. Is it clear and easy to follow, or are you thoroughly confused after you've been through those 2 chapters? I think they're reasonably well written. Personally, I think there are some issues with some of the examples that are given. They're not quite as clear as I might have liked, but they're a good place to start.
Thank you so much, Jill, and thank you, Molly and Jane. That's really, really good. Thank you. We've had quite a large number of questions come in, so thank you very much. I don't think we are going to get through all of those. I'm mindful that we've only got another 5 minutes or so. So I will just pick out a few, and we will endeavour to get back to those questions. The people have asked questions that we're not able to get to. We'll get back to you direct. So Jane, if I could start with you. Someone's asked a very sensible, practical question, which is how do we get hold of the, you talked about there being a couple of easy read booklets on the code. Where can people find those?
So on one of the slides, there was a link to the government website, and the government website lists the whole section of documents that are out there. So included in that is the easy read summary. Yeah.
Okay. Thank you. Thank you. And as I said, as Jane said, I think if the code itself appears a bit daunting, first of all, I absolutely echo what Jill has said in terms of the really key chapters to focus on, but the easy read guide and in fact the consultation document itself is helpful because it does say we have changed X, Y, and Z, and then ask some questions about it. So hopefully the link when we send around the slides and the recordings after this, by all means feel free to just click on that, and that should take you through. So thank you for that, Jane. Molly, in relation to the parts that you talked about, we've had a question about how do you see the role of GPs in terms of the medical assessment process, a part of the process?
Thanks, Neil. And it's a really good question. So in a lot of cases, people have their care primarily managed by the GP. So I think there will be an increased role for GPs going forwards to undertake that medical assessment. So it's about liaising with CCG's local authorities and ensuring that processes are clear. We understand timescales for this, but I think there is going to be a greater role. We already see at the moment when CCGs or local authorities are applying for community DoLS, often we're going to the GP to ask for a letter of diagnosis or a mental capacity assessment because actually there are no other consultants involved. So I think the role of the GP is only going to continue to increase.
Thank you very much, Molly. Jill, so we've had a question here, which I think is a very interesting question, one that I certainly picked up when I was reading through the guidance. And you've touched on it already, but someone has asked specifically here, which I think is a really helpful and interesting thought. They said here, the case studies in chapter 12 appear to be diluting the acid test. Do you have a view on that? Is that you mentioned maybe going back to the law as it was pre-Cheshire West? Is that your view?
I get the feeling that there does seem to be a move away from the acid test and from the position that we've all spent the last several years getting used to and feeling comfortable in. And I think, yes, I agree with that. I think it will be interesting to see what happens in terms of the case law, because I suspect we all remember dealing with cases where two very, very similar cases had two very similar outcomes with various district judges taking different views, and something was a deprivation of liberty and almost identical circumstances weren't. And I think that is going to be down to the interplay of these 4 points in relation to the confinement, the duration, and the effect of that, and the effect that it has on the individual. Once you introduce that subjective element of, is there going to be any hardship for the individual, you seem to be moving back to the Mumby comparator position that we had with Cheshire West before we got to the Supreme Court. So yes, I think there does feel to be an element of that. Whether it follows through in the final version of the code or not, I don't know, but certainly at the moment, yes.
Yes, thank you, Jill. That's very helpful. Right, we have sadly run out of time. I'm sorry we've not been able to get to all the questions. As I say, we will try to get back to people direct. There will be slides and a copy of this recording circulated. And if I could again just encourage you to do the feedback, that would be much appreciated. Other than that, thank you to all our speakers. Thank you to you for listening, and have a good day. Thank you very much.